Welcome to episode 41 of the Cashflow Connections podcast. Our topic for today is what does it take to protect your assets? Today, we're joined by an asset protection attorney to discuss a critical element of real estate investing, which is asset protection. As the saying goes, it isn't what you make, it's what you keep. But how hard is it to actually keep your wealth away from creditors, lawsuits, and divorce? In this episode, we're going to get into the details of some of the strategies used by typical accredited investors all the way to ultra high net worth individuals and everything in between. So we're going to talk about insurance and what role this plays in asset protection. We're going to talk about optimal entity selection when it comes to asset protection, as well as things like revocable versus irrevocable trust. This is a must listen for California residents especially. We're also going to discuss international asset protection. Is this something that is worth it? Does this make sense, or is this a waste of time and money? It's really important to look at that as a potential tool, especially if you're considering protecting significant amounts of wealth. And we're also, of course, going to get into a horror story of two and how our guest was able to resolve those matters without things getting way out of hand. So we go into a significant amount of detail, significant amount of content, jam-packed episode, and it's all free, despite our guest's hourly rate being, well, not free, I'll tell you that. Now, just as a reminder, if you haven't already signed up in iTunes, make sure to do so. This is the only way you're able to ensure that you're going to get new episodes as they come out. I'll make sure to leave a link in the show notes page that makes it as easy as possible. Just click the link that says subscribe in iTunes, and you'll automatically get new episodes downloaded to your iPhone. Also, while you're there, if you have the opportunity to leave us a review, that would be greatly appreciated. And of course, if you haven't already created an account with Cashflow Connections, you should do that too. So just go to cashflowconnections.com, create an account. We have some really exciting things coming up. It's too early to discuss right now, but if you go to cashflowconnections.com, create an account, you will be the absolute first to find out if these developments do move forward. And of course, you can also follow the link in the show notes page, which says create an account. All right, hope you enjoy the episode. How's it going, everyone? Our guest for today is Brian Chou, who is an associate attorney at the firm Barth Calderon. His practice focuses on asset protection, estate planning, and business succession planning. Mr. Chou assists clients in all stages of life, from a young professional couple that is concerned about estate planning for their minor children to the wealthy real estate investor who wants to insulate himself and his properties from lawsuits, to the successful business owner who is agonizing about how to transition his company to the next generation. So, Brian, really appreciate you coming on. We obviously haven't talked about this yet. It's absolutely critical. So thanks again.
Great to be here, Hunter. Really appreciate the opportunity.
100%. So before we jump into asset protection, I want to learn a little bit more about your background, what got you interested in legal space as a whole, and then how you got interested in the asset protection space, which is kind of a niche in its own.
Sure, Hunter. I wish I could tell you that, as a little boy, I wanted to grow up to be an estate planning and asset protection attorney, but really that's not the case. I kind of fell into estate planning first, kind of by dumb luck. I had graduated from law school with a JD MBA, so I had a business background and a law background, and it started out in litigation and didn't really, as a naive young lawyer, I just kind of assumed, that's what lawyers do, is they fight with one another all the time, and through just a chance job interview, I got a job with an estate planning firm. And those jobs are not necessarily easy to come by, but it was really eye-opening for me because estate planning, there are parts of estate planning and asset protection planning that are completely the opposite of what you would expect a lawyer to do. It's very consultative. You're meeting with clients. You're helping them to really make the pie bigger, helping them to spot issues, and help them to structure their assets to accomplish their goals before anything goes wrong, ideally. And so you do a good job and clients really love you for it. And you're building them up and creating win-win situations for them and the people that they're interacting with, rather than trying to live in a zero-sum world where you're trying to tear somebody else down to make your client better. So that really kind of resonated with me and my personality and kind of my life philosophy. And as I progressed in estate planning, I actually got a job at this particular firm I had actually met my boss, Harry Barth, who is a very prominent asset protection attorney. And he really kind of gave me this opportunity about 6 years ago to really move upstream. So I was working for an estate planning firm doing estate plans for mostly middle to upper middle class families, but I had really kind of gotten an itch to do more complex planning for higher net worth individuals. And so for the last 6 years, I've really been focusing on that and really doing more complex planning to help these business owners, professionals, real estate investors to identify risk and to plan for that risk. A pound of or a spoonful of prevention is worth several pounds of the cure. So it's really gratifying to be in this space and to really be working my way towards becoming an expert in this and a very valuable resource for my clients and my professional contacts as well.
I appreciate you kind of sharing a little about your background there. It definitely gives us an idea of the perspective as a whole. So let's talk about why this conversation is important. When it comes to asset protection, what are some of the main reasons people need to pay attention to this podcast?
Yeah. So first of all, it's hugely important, I think, for the listeners of this podcast, because most of them are real estate investors, right? These are people who have worked hard during their lifetime to accumulate the various assets that they have, whether it be fix and flip, whether it be buy and hold. Many of them have day jobs. Maybe they're professionals as well. Maybe they're doctors or lawyers. And this is hugely critical, I think, in large part because we happen to live in the most litigious country in the history of the world. I wouldn't be so presumptuous to say the universe, but certainly in recorded human history, the United States is the most litigious country in the world. And so to give you a little bit of context, 95% of all lawsuits filed in the world are filed here in the good old US of A. Somewhere in the neighborhood of between 12 to 15 million lawsuits are filed every year in civil court alone, so not even including criminal court. So there's a lot of liability out there. And so what I would stress to your listeners is, for many of them, they're really living in that perfect storm, right? So not only do they live in the most litigious country in the world, they live in California, which along with New York are the most two litigious states in the union. They are probably wealth accumulators or have significant wealth already. Just as the nature of being a real estate investor and accumulating passive income, it tends to build upon itself. And then they're also engaged in high liability activities. Just again, the nature of owning real estate comes with a lot of liabilities: tenant lawsuits, partnership disputes, personal guarantees to the bank, things like that. So, and that's also just overlaid on top of any risky activities that they do generally, right? Driving fast cars, going to the shooting range, etc. So that's really kind of the perfect storm in which a lot of my clients, and I would expect a lot of these listeners, exist. And so you can think of, if you go back to Physics 101, right, the more mass you accumulate, the more gravity something has. It's the same thing with wealth accumulation. The more the more wealth you accumulate, the more financial gravity you have, the more liability is attracted to you, the more likely it is that somebody's going to try to take those assets away from you. So that's really why having these conversations is hugely important.
Yeah, I appreciate that as well. And, it's interesting. I'm sure that you've dealt with some really incredible clients over the years, particularly at your new firm. And I definitely want to get into the details in terms of the entities you like and the structures and all that. Before we really jump into that, let's talk about insurance briefly. I know that
Sure.
This is probably a big piece, I guess the first piece, or I guess you want your perspective on that. But how do you view insurance, and what are some of the limitations of insurance when it comes to asset protection?
Sure. That's a great question, Hunter. So this is something that comes up a lot with our clients. And oftentimes the question is, or the assumption is, oh, I have insurance. I have a $2 million umbrella policy. I can sleep well at night and everything's hunky-dory. And My response to that is insurance. We love insurance. Insurance and asset protection are not mutually exclusive. In fact, they're best used in conjunction with one another. And insurance is really, I like to describe it as the gateway asset protection vehicle, in large part because insurance is fairly ubiquitous. And on a very base level, it's fairly easy to understand and fairly easy to implement. Certainly, you can get into the weeds when we're talking about coverages, indemnity, etc. But insurance, there are shortcomings to insurance. I think that's the first thing that any client or any prospect or anyone that's considering asset protection should know, which is insurance. Insurance is great. We want it, but one of the drawbacks of insurance is it tends to draw people into a false sense of security. Exactly what I was saying before. Hey, I have my $2 million or $5 million umbrella policy. Everything's fine. Nothing can touch me. I'm great. I don't need to think about this anymore. But what a lot of times people fail to consider is that insurance companies are out there to make money, just like any other business entity, and they can't insure you for everything without charging you an arm and a leg and your firstborn child. So if you look at your insurance policies, pages 1 and 2 deal with what's covered. Pages 3 through 15 or 30 deal with what's excluded. And so these exclusions are typically born of lawsuits. So let's say that we have Joe policyholder, his house catches on fire, and he decides to put in a claim with State Farm. State Farm decides that they don't want to pay that claim. Joe policyholder now goes to a judge and he brings a lawsuit against State Farm. A judge says, hey, you've got to pay this claim, State Farm. State Farm says, okay, well, we'll pay this claim, but we don't want to pay any future claims. So what they'll do is they'll exclude that instance out of their future policies. So now what we have is a bunch of holes in the Swiss cheese, right? So these exclusions tend to be high liability, low probability events. But what is the insurance really there to provide? It's basically primarily there, for most people, it's there to keep us from having to go to the poorhouse in case the poop hits the proverbial fan, right? And so that's something that's hugely important to know. Another issue is if something may be technically covered by the policy, but if the insurance company decides that they don't want to pay it, and now you have to sue them while you're defending yourself from the lawsuit, that's not fun either. Beyond that, insurance also comes with limitations, right? So if you have $1 million umbrella policy, but a $5 million loss, you still have a $4 million problem. And then last but not least, there are limits to the insurance company's level of solvency as well. So that's another thing to consider, especially if you're going with smaller companies. You may get a great rate on a policy, but when it comes time to pay out, if that insurance company is insolvent or unable to pay those claims, now all of a sudden you have to go to the state fund, and good luck getting some sort of payment, from full payment or timely payment from the state as well. So those are all limitations of insurance. Now insurance is great. We want insurance, and insurance works really well with a lot of these asset protection structures that we put together. So one analogy I like to use is when you go camping, right? You got the cooler, the igloo cooler with all your food in it. You typically aren't going to keep the food in the tent, right? You want to keep the food outside in a tree. So if a bear comes by, they're going to go after the igloo cooler. They're not going to try to break into the tent. So the insurance kind of plays the same role. Insurance is kind of like the low-hanging fruit that a creditor can go chase after. And we build these kind of armadillo asset protection structures around your house, your bank accounts, your investment accounts, your rental properties, your businesses, so that we drive that liability away and towards the insurance, because that's what it's designed to do. Another benefit of insurance is a lot of times people assume, hey, if I harm somebody, I'm just going to sit back in my castle and I'm going to laugh and I'm not going to pay out a dime. But the truth of the matter is most people are moral individuals. So if we genuinely harm somebody, the insurance provides that liquidity for us to make something right. But because we do it in conjunction with these asset protection structures, we can do it on our terms. We don't have a plaintiff's attorney threatening us, saber rattling, saying that they're going to take, my house or my bank accounts. I'm able to negotiate on terms that are friendly to me, so I can make informed decisions about what I think is right and negotiate on my terms. Make sense?
Yeah, absolutely. Basically, you have a policy that should be large enough to cover instances that take place, so that in the event that a creditor wants to, I guess, pursue, they look at the policy and say, okay, look, that will satisfy this claim. We take that, or we get compensated that, and we just move on rather than go through the litigation process.
Right. That's the easy money, right? So it's a place to drive, creditors are kind of like water. They tend to follow the path of least resistance. So if you can create more resistance towards the assets that you've built up and drive everything towards the insurance, or better yet, to other people who have less asset protection, then that's in large part a way to create that breathing room and to create that negotiating leverage. So,
got it. And when it comes to, I guess, asset protection in terms of your world, what are the typical structures that you implement? What entities do you suggest people utilize when it comes to your clients?
Sure. So I'll start by saying, and this may be a recurring theme, is, it'll all depend on, the facts on the ground, so to speak, because every clients are like snowflakes. They're all, have different priorities, shapes, sizes, and facts surrounding their situation. But when we talk about asset protection planning, certainly we'll use a whole host of different types of entities. So corporations, LLCs, limited partnerships, different sorts of trusts, both revocable and irrevocable trusts. And then even within those, there are substructures, right? Or there are sub categories when you're setting up these types of entities as well. For instance, with LLCs or corporations, right? It's not as simple as just saying, hey, LLC, right? We're then talking about, okay, well, how should that LLC be structured? What state what venue should we use? Should it be in California? Should it be in Nevada, Delaware, right? Should it be single member, multi-member? What's the tax, what sort of tax status do we want to elect? How should that LLC be held? Should it be held by individuals? Should it be held by a trust? Are there sub-entities within that? So there's a lot from an architectural standpoint. There's a lot to consider, and it all is really handcrafted or custom crafted to the client's situation. And I also want to just take a step back as well and say, entities are one way that we help our clients to build that structure, but there are other things that we can also do to create asset protection benefits as well. For instance, utilizing insurance, or the way that you title a property. For instance, owning a property as community property with your spouse, or choosing not to do that, to own it as tenants in common, can have asset protection benefits as well. The use of debt on properties can also create asset protection benefits as well. So there are a number of ways to skin a cat, so to speak, but and entities are one of the types of tools that we utilize, but there are others that kind of fall that are also in the tool bag.
Okay, and you obviously touched on a lot of points, and this podcast is not afraid to jump into details, so I'm going to have to go through one by one and kind of unpack each one of those. So
sure.
First of all, let's talk about revocable versus irrevocable trusts. First of all, what are those, generally speaking? What are the benefits and what are the drawbacks? And I guess, we'll get into that first, then we'll go into some more of those questions. So
sure.
Let's start with revocable versus irrevocable.
So let's talk a little bit about that. So we'll start with revocable trusts, right? So I want to start here just because your audience and just people at large are probably most familiar with revocable trusts, and so for the people that have engaged in some sort of estate planning, which is what happens to your stuff when you die, or if you become incapacitated, a revocable trust is a really key entity that people use to do that, right? So essentially what people will do is they want to make sure that if they die or become incapacitated, that their loved ones, the people that they appoint, can easily step in and carry out their wishes, whether it be dividing the assets up amongst their children, transferring them to charity, managing their real estate portfolio for several generations to come, whether it be making managing things in the event of their incapacity, right? So This is hugely important because most people, when they go through life, as they acquire assets, they acquire those assets in their own name, right? So, for instance, I buy a house, my name is on the deed, or I buy a car, my name is on the pink slip, or I open up bank accounts or investment accounts, my names are on those accounts. So if I own a house, right, and it says Brian Chou on the deed, I'm the legal owner. I can do whatever I want with those assets, buy, sell, refinance, remodel the kitchen, no problem. But if I die, I have no more actual authority to make any decisions, but I'm the only person on title to the property. There's no mechanism for anybody else to step in. And so because of that, that property just sits there. It's not being rented out. It's not being lived in. It's not being productive. And so at that point, it falls to the state to figure out what to do with my stuff, right? And so when the state has to get involved, we have something called probate, right? So these assets have to go to court. It's very expensive. It's time consuming. It's public. It's a huge pain that people don't typically want to deal with. So one of the ways they avoid this is they'll create a revocable living trust. And so this is a separate legal entity, similar to a corporation or an LLC or some other entity, right, that exists separately from you or from me. So I create a living trust, right, and I transfer ownership of my assets to that trust. So my house, my bank accounts, my rental properties are all now held in the name of the trust. So the trust owns all that stuff, but I'm the CEO or the manager of those assets, right? So during my lifetime, I can do whatever I want with those assets. In the event of my passing, let's say I appoint, well, let's do this. In the event of my passing, I, Brian Chou, the individual, died, but everything is not owned by me. It's all owned by my living trust, which exists after I'm gone. And so what happens then is during the course of my lifetime, I manage everything. But let's say I appoint you, Hunter, as my successor, right? My vice president. If I'm gone, you now step up into my place. And now you have the ability to manage those assets and distribute them to wherever I appoint, right? So if I say my house goes to my son, you, Hunter, now have the ability to transfer those assets to my son. And we can do all of this outside of the probate process, which keeps it out of court. It's much less expensive, typically much less time consuming. And it's also private so that every Tom, Dick, and Harry off the street doesn't get to see what kind of assets I have and where everything is supposed to go. Okay. So that's why a lot of times people will engage in putting together a revocable living trust. And these are very popular, right? So most people who are engaging, their first interaction with trust is with a revocable trust. Now, your question may be, what makes a trust revocable? So a revocable trust is designed so that the creator, in this case me, I would have the ability to make changes to the trust however I want during the course of my lifetime, including completely getting rid of the trust. Okay, so if I wanted to undo the trust, I can blow it up and everything just comes back to me. If my kids get married to somebody I hate, I can write them out of the will, right? Or I can write them out of the trust because I can change it however I want because it's revocable. So a revocable trust, again, it's really good for estate planning purposes, but it's not so good for asset protection purposes. And the reason is because it's revocable. So if I get into a car accident, somebody sues me and they say, hey, I have a $2 million judgment against Brian and I want to get at all of his assets. I go to a judge and I say, hey, judge, and this is, again, a common misperception that a lot of times my clients will say is they'll say, hey, I have this revocable trust. I don't own anything. It's all held by my revocable trust. Can I avoid asset protection or can I avoid my creditors because I technically don't own any of these assets? And the answer is no, because guess what, right? If I tell a judge, hey, all these assets are owned by my revocable trust, I don't own anything. Why should those assets should be subject to the claims of my creditors? Well, a judge is going to say, hey, I looked at your trust, you actually retain the ability to undo your trust. You can revoke it. So I'm going to order you to revoke that trust. Everything comes back into your name. And now I have to pay all my creditors. And so that is one common misperception that people have about revocable trusts is, hey, it'll protect me if something happens. And the truth of the matter is it's great for estate planning purposes, not good for asset protection purposes. So what can we do from an asset protection point of view? So asset protection, what we'll oftentimes utilize are irrevocable trusts. So these are trusts, just like the name, it's designed so we have limited ability or no ability to change the terms of the trust. So once I set this thing up, the terms are set. I don't retain strings to be able to pull assets back into my name. So let's say I set up an irrevocable trust for the benefit of my son, and I say, hey, I'm going to transfer $1 million to this irrevocable trust, right? I transfer $1 million. let's say, Hunter, I appoint you as the trustee. You're in charge of managing it, right? And now as the trustee, you have a legal obligation to use those funds in accordance with the directions of the trust, right? So everything that gets placed into the trust, you have to use for the benefit of my son. So he wants to go to college, you pay his tuition, et cetera, et cetera. So what happens then is once I've transferred those assets, I no longer own those assets, right? So they're no longer subject to my control. They're no longer subject to, I am no longer the beneficiary of that asset. So just like as if I had given you that money, Hunter, just as an individual, and I get sued the next day, those assets no longer belong to me and they're not subject to my creditors, right? And so same thing, if I transfer these assets to this irrevocable trust and a creditor now comes back later and says, I want those, I've already given it away, it's gone, right? And so a court can't compel you, Hunter, to transfer those assets to me because those assets, you didn't create that liability. That liability comes through me. And same thing, because you're not me, you can't be compelled to distribute those assets for the benefit of my creditors, because that would be in violation of your duty as trustee of the trust of the irrevocable trust that I set up. Make sense?
Yeah, absolutely. And I appreciate you going through that level of detail. So I guess then the obvious question that comes up a lot in these conversations is, can you create an irrevocable trust in which the beneficiary and the trustee are really the same person? I mean, what are your thoughts on that? And what are the case laws in terms of that particular structure?
Yeah. Okay. So great. This is a perfect question. So yes, the answer is yes. You can create irrevocable trusts where the beneficiary and the trustee are the same, but there may be some limitations from an asset protection standpoint. So let me back up and talk a little bit about what I think your audience will be more interested in, which is, can you create an irrevocable trust for the benefit of yourself? Because the example that I gave earlier was, hey, I'm transferring $1 million for the benefit of my son, right? And so when I give that asset away, those assets are no longer, again, my assets and no longer subject to the claims of my creditors. But the question then becomes, what if we change the facts? I create an irrevocable trust. Hunter, you're the trustee, and the assets that I give to you, you're legally obligated to use for my benefit, right? And so that's where a lot of our clients want, right? They say, oh, well, it would be great to, give away money for the benefit of our children or other loved ones, but what if we need that money for us? What if that's part of our retirement plan, or we want to be able to spend that money because we worked hard for it during the course of our lifetime to accumulate those assets? We don't want to just give it away. The answer to that is yes. So we do have the ability to create irrevocable trusts for the benefit of ourselves, but that is more complicated than if we're doing it for others. And the reason for that is because many states, California included, do not recognize these types of trusts from an asset protection standpoint. So California says, hey, if you're setting up a trust here in California, an irrevocable trust for the benefit of yourself, as a matter of public policy, we don't want you to be able to avoid your creditors. So we don't recognize these types of trusts as it pertains to asset protection. So if I create a trust here in California and somebody sues me, an irrevocable trust for the benefit of myself, then those creditors, a California judge will just allow those creditors access to that irrevocable trust, and it's not really worth much from an asset protection standpoint. So, but the good news is there are other states, a growing number of states that recognize these types of trusts and are very favorable to these types of trusts. The most the two jurisdictions that are really kind of leading the vanguard are Nevada and Delaware. So what they do is they say, hey, we really like these types of trusts. We want to encourage people who are wealth builders and wealth creators to do business in our states, and we want to make our laws as friendly as possible to these types of people. So Nevada, for example, they'll say, hey, so you can set up these types of trusts as long as you meet these minimum thresholds, which are, a certain portion of the assets are custodied in Nevada, and the trust is managed by a Nevada trustee. And so what happens then is, now let's say I create that same irrevocable trust, but it's now custodied in Nevada, right? And what happens is I transfer that $1 million. It's held in a bank account where, let's say in Nevada, it's managed by a Nevada trustee. Same lawsuit comes on. Creditor says, okay, we see that you have $1 million in this irrevocable trust in Nevada for the benefit of yourself. California judge will say, hey, as a matter of public policy, we don't recognize these types of trusts, so we're going to allow your creditor access to that. But the difference here is, now, in order for that creditor to enforce that judgment, they now have to go to Nevada to compel the trustee to distribute the money. So in Nevada, what happens is a Nevada judge will say, well, as a matter of public policy, we look on these trusts very favorably, and we're not going to order this trustee to make that distribution, absent some very bad facts which show that I'm, making a transfer solely to avoid, paying my existing creditors, right? And so what happens is, then now we have the laws of California butting up against the laws of Nevada, and it creates a ton of uncertainty for creditors, such that the collectability of that judgment is extremely in doubt. And so in 20 years of these types of trusts being in existence, there's never been a lawsuit which has settled that issue, just because the time, effort, and expense that it would take to come to some sort of a decision, people aren't willing to pay that price. And so everything tends to settle or everything has settled up to this point without ever reaching any sort of conclusion there. And so that's really the name of the game from an asset protection standpoint, is not necessarily to be bulletproof, which a lot of times people assume that that's the end goal. It's to make it as difficult as possible for creditors to get to your assets in order to promote settlement. And so that's what we want to do, is we want to create more certain settlements that are more favorable to you for less money, less time, and less headache, is really the idea.
Got it. And I think that that's definitely the key. It's also, when creditors look at the structure that you're implementing, look at the entities, and look at the states in which they're in, they basically say, look, we should just move on, basically, rather than pursue this, from a litigious standpoint. From a functional standpoint as well, just to kind of provide some clarity in terms of how you implement that strategy. So, I know some people from Vegas. I certainly don't want them managing any trust that I own. For the ones that I happen to know, no disrespect, of course. So functionally speaking, how do you kind of facilitate those relationships for your clients? Do you have attorneys there that are, in that position, or who typically occupies that role?
Yeah. So we typically use a trust company out in Nevada. And so essentially they operate as the distribution trustee. So they're the ones in control of the distributions from the trust. And so usually when we prepare these types of trusts, our clients can oftentimes be in control of the investments. So if they want to choose to invest in certain things, like, hey, I want to sell some bonds and buy some stocks, they can. They can direct the assets and how they're managed. But what's critical is the distributive power, right? We don't want our clients to have the power to control the purse strings, because if they do, then a judge can compel them to exercise that power. So the Nevada trustee primarily sits in that role, and they charge a nominal fee. It's a little under $2,000 a year to act as the trustee, and to coordinate with our clients as far as making distributions as they need it. But when something goes wrong, then again, they can shut off the spigot so that those assets are not exposed to their creditors.
Cool. Got it. And I appreciate the extra level there, because that's something that doesn't get talked a lot about. But obviously, if you're going to be, considerably investing, meaning that you have a lot of transactions, this is one of the things that could potentially be a headache, which is frequently having to go through a third party to do that. Now, this headache comes along with a really solid asset protection program. So it's really a scale of how many assets you're trying to protect, the complexity at which is justified by those assets, and what you're trying to go through in order to make that veil very unpierceable.
Sure. And one corollary, Hunter, if you don't mind. So the other thing that oftentimes gets overlooked is this, right? So when we're talking about transactions, we can structure those assets so that a lot of the day-to-day management can be done by the individual client. So for instance, if you have somebody that's a fix and flip that's got an LLC that he's running a fix and flip business out of, right? He can still be the manager of the underlying LLC. It's just that the top level entity where all of the proceeds funnel into will ultimately be the Nevada trust. And so if this person's running, let's say he's got a California LLC, which is kind of plugged into this overall structure, he can still do the day-to-day management within the LLC as far as fixing and flipping homes. It's just that if he gets sued personally, in order to compel any distributions from the proceeds that are generated from that business, it would have to go through the Nevada trustee. So if somebody is running an active business, they can still benefit from this type of structure without giving up the day-to-day control of the business itself.
Got it. And again, of course, that does probably alleviate that headache. But then again, they're creating another LLC, which is kind of the whole point of this conversation, which is that the complexities can be mitigated due to a variety of factors. You mentioned California. This is obviously a really unique state. Not all the listeners are from California, of course, but it's obviously interesting when it comes to asset protection as a whole. First of all, why is that? And what are some of the major differences between California and some of the other states out there?
Oh man, California is I don't know. I mean, we're special. It's I think a part of it, and this is just my own editorial, but I think California is. I think that it's unique in the sense that we have the luxury of looking out for the little guy more, and I don't mean that in a way. I don't mean that to say that the little guy is always right or that the big guy is always wrong, but I think because there is so much wealth in California, we can afford as a society to devote more resources to social safety nets, to programs to promote the well-being of people who don't have a whole lot of assets, and I think that those are good things generally. I mean, if we have the resources to look out for the least among us, that's an admirable goal. But one of the side effects of that is people overstep or they push back more than what was intended, right? So and because of that, I think it becomes more critical living in a state like California for those of us who have accumulated significant assets or plan on accumulating significant assets to do the proper planning, understanding the reality that judges and juries tend to favor the little guy, everything else being equal, or perhaps in situations where things aren't so equal. But just understanding the optics, right? Is if you ever end up getting sued, you will likely end up in a place that is, whether it's a judge or a jury, that's going to be very pro plaintiff, and understanding that reality that even if you're completely not at fault, that fault could be assigned to you. That just kind of basic self preservation would dictate doing planning up front to ensure that when those rainy days come, that you're prepared.
Earlier in the conversation, you mentioned kind of the tenants in common versus the community property laws. Is that also related to common law versus community property states, like common law states versus community property states? Is that a defining factor? Is it just the tick? Is that unrelated to that whole distinction?
No. So California is unique in that way too. And actually, I'm glad you bring that up, Hunter, because so not only are we unique culturally, but we are unique in the sense that we are a community property state. And this is also hugely important for those of your listeners who live in community property states. So there are 11 of them in the union. Everybody else is a common law state with the exception of Louisiana, which operates under Napoleonic Code. And Hunter, if you would refrain from asking me any questions about the Napoleonic Code, I would be much appreciated.
Oh, we could go on about Napoleonic Code for hours. Well, that'll be a different one.
Yeah, we'll do another podcast on that. So one of the features of community property that's, I think, critical for those of us who live in community property states is, let's say we have a husband and a wife, Hank and Wendy. Hank, before they got married, they were two separate people. So Hank, he earns a paycheck. That's his money. Wendy, she earned a paycheck. It was her money, sole and separate, no problem, right? Once Hank and Wendy get married, absent a prenuptial agreement or some other exception, they essentially become one person or one entity. So the state looks at them as if they're one person. So a lot of times people assume that community property, right, whatever you acquire during your marriage is considered community property, again, absent certain exceptions. And when people own things as community property, they usually think, oh, I own it 50-50 with my spouse. But that's actually not true. That's only true in the event of a divorce. While you're married, it's actually owned 100-100. So it's owned essentially by one person. And one of the features of community property is it's 100% exposed to the liabilities of both spouses, right? So if Hank gets into a car accident and somebody sues him, it doesn't matter that Wendy wasn't involved. Hank's liability attaches to 100% of whatever they acquired during the course of their marriage, absent certain exceptions. But so that's a really, really bad result. I mean, if you use the example of a home, Hank and Wendy own a home together, primary residence, and Hank gets into that car accident, Hank's creditor can now foreclose on Hank and Wendy's home, right? And then Hank and Wendy get a check. They get a check for $100,000, which is the extent of California's homestead exemption, which is, we can get into the details of that at some point as well when we talk about exemption planning. But so that's not a very good result, right? So what happens instead is, let's say Hank and Wendy choose to opt out of community property, which is something that a lot of times people don't think about, is you have the ability to contract freely with your spouse to agree how you hold title to your communal assets or to the assets that you own together. And so what we would do in this case is we can execute what's called a postmarital asset protection agreement. So this is basically a way for Hank and Wendy to agree that they no longer want to hold their assets as community property. They're choosing to hold their assets as if they were residents of a common law state. For example, New York, Massachusetts, Georgia, etc. Right? So instead of owning everything as 100-100, Hank now owns an undivided 50% interest in their community assets, and Wendy owns an undivided 50% in their community assets. What's even more important is the liabilities of Hank and Wendy are their own, right? Instead of Hank's liability being a community liability, his liability is his and her liability is hers. So now we have that same car accident where Hank gets sued. His liability can only extend to his 50% of the assets. He only owns 50% of the house. So the creditor, first of all, they don't have exposure to the 100%. Second of all, best thing they can do here is to get a lien against their property. They can't force the sale of the home because guess what? Wendy wasn't involved, and her portion is not subject to Hank's liability. So now what happens is the creditor can't just come in and take the house. All they can do is wait until the house is sold, at which point they would get 50% of that value, right? But Hank and Wendy love living where they're living. Their kids are in a good school district, right? They're just going to continue to stay there forever. And what do creditors typically want? They want their money and they want it yesterday. So if that's what they want, then they're much more likely to come to the bargaining table to say, look, we can't squeeze blood from a stone here. What can we do? And then again, that promotes settlements for a lot less money, a lot less time, and a lot less headache than we otherwise would have had they not done this relatively simple thing to provide that additional asset protection. So that's a big chunk, or that's something that's hugely important for those of us who live in community property states, is just understanding how that liability can flow.
Before we kind of move on from California, I'm also interested in terms of prenuptial agreements. Obviously, asset protection is critical when it comes to something that may go wrong on a property, but then there's also things relating to, the prenuptials, et cetera.
Yep.
What are your thoughts on the status of prenuptial agreements in California? How easy are they to be violated? What are your thoughts on the current state?
Yeah. So prenups are, I think, a very, very good and pragmatic thing to have. Now, I think a lot of times the challenge with the prenuptial agreement is getting buy-in from the spouse. But a lot of that is done on an interpersonal level. So it's I think that prenups, generally speaking, are good to have. The enforceability of prenups is you want to have qualified people draft these things, because there's a lot, the chance that they'll be challenged is high, being that the divorce rate in California and the United States in general is pretty high. So you want to make sure that you have qualified people working on this thing to maximize the potential for enforceability.
Okay.
You want to make sure, and family law isn't necessarily my area of expertise, but just based on my exposure to prenuptial planning, you want to make sure it's critically important that both sides are independently represented by their own attorney. And I'm specifically talking about prenuptial agreements as opposed to postnuptial agreements, which is what our firm does a lot of. But you want to make sure that each side is represented. They have adequate opportunity to negotiate, that everything is adequately, all the assets are adequately disclosed to each side, to make sure that there isn't, or to minimize the possibility that that agreement would get set aside down the line, because the court is inherently very concerned about making sure that the agreement was fair for both parties, that one party wasn't exerting undue influence over the other. Another thing to think about prenups is, so I'll run into prenuptial agreements. I have clients that have them. And even when they have prenuptial agreements, it may, from an asset protection standpoint, also help to have a postnuptial agreement to redefine the community property rights. Because sometimes, like for example, I had a client the other day that came in, recently married to her new husband. They had significant assets prior to marriage, and their prenuptial agreement said, hey, what was mine before marriage, we're specifically itemizing those remain my separate property. And then same thing for him, but then their prenup also said anything that we acquire in the future would still remain community property, right? So in that situation, we were considering utilizing a postnuptial agreement saying, hey, even though we're subject to this overarching prenuptial agreement, we no longer choose to own our future assets as community property. We prefer for those assets to be owned 50-50, sold and separate, and to opt out of the community property system. And so even if you have an existing prenuptial agreement, the postnup may actually supplement that, depending on the terms of the trust or the terms of the agreement. So,
okay, cool. And before we, I guess, close up the conversation, I definitely want to give you an opportunity to discuss international trust. Is this something that you guys implement as part of this strategy, or is that something that the complications aren't really worth the outcome?
No. So we use offshore trusts all the time with regularity, and so offshore trusts are very, very powerful tool. They're not appropriate for everybody, but for those clients that have significant asset or have very, very strong asset protection concerns, or they really want to make sure they lock things up as much as possible, this is a really, really good way to do this, especially before something goes wrong, right? So one takeaway here is, with a lot of the asset protection planning that we do, it works way better before you have a liability, right? Mm-hmm. Because after the fact, planning, your creditor and judges have way more leeway to potentially undo structures that have been set up after something bad has happened. It doesn't necessarily mean that you shouldn't or couldn't engage in asset protection planning, and in many cases, it makes a lot of sense to do so, because it still can create leverage, right? So, but from a planning perspective, if you do it beforehand, it's even more powerful, right? So an important takeaway for the audience members is, if you have assets that you really don't want to lose, if something bad happens, then now is the best time to start planning before that auto accident or before that tenant slip and fall. After the fact, there are still options, right? And it's still good to do planning when something bad has gone wrong, because even if there's an existing creditor, getting your ducks in a row for future creditors is hugely important as well, right? So, but that being said, from an asset protection standpoint, offshore trusts, offshore asset protection trusts are a really, really great way to provide a high level of asset protection. And so I'll start by talking a little bit about the irrevocable trust that we had set up for the benefit of ourselves in Nevada, right? So we had talked a little bit about that before. So this is a similar structure, except that it's now venued outside of the country, okay? And the benefit here is that, so for example, a jurisdiction that we use, the jurisdiction that we use most often for our offshore trusts is the Cook Islands. And so, so the Cook Islands, the difference between the Cook Islands and a state like Nevada is not a part of the United States. So there's something called the full faith and credit clause of the United States Constitution, whereby states will respect the laws and judgments of other states. So if somebody gets a judgment here against me in California, and they now take that judgment to Nevada, Nevada is bound by the Constitution to respect or at least acknowledge the existence of that judgment, right? Even though a Nevada judge may not compel the or carry out that judgment or compel a trustee to abide by that judgment, they still at least have to recognize the existence of that judgment. So what happens is, if we go overseas, what happens is the judgment that's entered here in California isn't worth the paper it's written on in the Cook Islands. So what they would have to do, a creditor here would now have to go to the Cook Islands and bring a lawsuit there to compel a distribution from a Cook Islands court. And so, so what happens there is, in the Cook Islands, a couple things to note. In the Cook Islands, they don't have contingency fee attorneys. So I assume your audience is familiar with contingency fee attorneys, whereby here in the States, if you want to bring a lawsuit, you don't necessarily have to come up with money up front. If an attorney thinks you have a good case, they'll oftentimes front the cost of bringing that lawsuit and get paid on the back end as a percentage of the settlement, right?
Yep.
Okay. So
very common.
Yeah. In the Cook Islands, they don't have that. So now a creditor has to come out of pocket to bring that lawsuit. The standard of proof that they have to show to say that the transfer of your assets to that Cook Islands trust was avoidable or a fraudulent conveyance. Essentially, you transfer those assets improperly as a way to avoid having to pay your creditors. The standard is a lot higher. The standard of proof is a lot higher there than it is here. So here, the standard of proof is a preponderance of the evidence. There, it's what's called clear and convincing evidence. So if we think about it on a football field, preponderance of the evidence means getting past the 50-yard line. Clear and convincing means at the very least the red zone and perhaps further, right? Mm-hmm. So that's a much higher standard of proof. The statute of limitations are shorter as well in the Cook Islands, and there are also provisions whereby you can actually switch jurisdictions. If there's a lawsuit in the Cook Islands, those assets could then be the trustee can essentially pull a ripcord and have those assets transferred to another jurisdiction. So it's so what that does is it makes it highly unlikely that a creditor will be able to ever get at those assets. And if they really wanted to make a concerted effort to do so, it would cost them tons more time, tons more money, tons more headache to be able to get at those assets. And so it would require an extremely motivated creditor to really chase those assets down, if at all. And so because of all the uncertainty and the costs, the time, and the headache, that is a really powerful way to promote settlement when you have, again, motivated creditors that are coming after your things.
And I know that each situation is going to be different, but just for the listeners to have an understanding of scale, at what level of assets do you start to implement something related to the Cook Islands, regardless of the complexity? Is this something that happens at 1 million, 5 million, 10 million, 50 million? Just to
I'd say $1 million is probably a good number to start considering. I mean, there are situations where people might do it less than that.
Mhm.
But every client is different. I don't think that I would think that $1 million is kind of where I would start thinking about it, but it'll just depend on each client's individual risk profile and then the facts of their circumstances, because they might be hot to trot if they just
Mhm.
got into a car accident or had a major liability, and so it really just depends on the individual client. But if we're just talking about scale, I'd say $1 million is a good starting point to start thinking about that. And usually when clients come to me, that's a big part of the initial analysis, is really kind of talking through, what's keeping you up at night, what are your concerns, what is your current fact scenario, what are your goals, and then from there we can start kind of dialing in. Okay, well, maybe you should be considering offshore trusts, or maybe a Nevada trust would be more along the lines of what you're looking to do, or maybe you just need a couple of LLCs because you have a couple rental properties, and we can get to a place of significant asset protection that fits comfortably within your budget, right? Because that's the other thing too, is all of these things, they don't happen for free, and they certainly don't happen automatically. So a big part of that is kind of making sure that the client understands the pros and cons of each particular project or each particular proposed action, and then from there helping them to make informed decisions about what really makes sense given their budget, given their goals, and given their concerns. So.
Awesome. And obviously, a lot of this conversation has kind of circled around getting this handled up front as opposed to waiting.
Yeah.
Having said that, I think probably the reason that you've repeated that several times is that I assume you have been in some situations where clients have not heeded those words. So yes. I was hoping, before we close out, just to kind of give an example of a horror story. Of course, anonymousness would be respected, of course. But how you were able to resolve that problem via your strategies when it comes to asset protection. Sure.
So and I will start by saying this, right? So many of our clients come to us after the fact, as you can probably imagine. The ideal scenario is something bad happens, but not so bad that you're in serious hot water. And those are oftentimes the best because they provide the motivation for a client. I had a client the other day that I met several months ago. Real estate investor, owned a bunch of properties in Maryland, and we were talking about getting them into LLCs just as a basic asset protection structure. And he was kind of hemming and hawing and was like, I don't know if it's going to fit into the budget. I have so many properties. I don't know if I want to set up all these entities. And 4 or 5 months passed by, and he calls me out of the blue last week and says, hey, I want to get a Nevada trust in place because one of my tenants stabbed one of my other tenants' boyfriends on the premises. It was just like, oh my God. And so luckily for him, that current property was already in an existing LLC. So there is some protection there already, but the impetus for him to get all of his ducks in a row, right, oftentimes comes from something bad happening. So yes, best to get your stuff done beforehand, but if not, there's always things that we can do. Even if we have something bad really happens to a client and it doesn't mean that we just stop planning. It means that, when you're motivated, we want to start the planning process and figuring out how to set things up. How effective it is against that current creditor will oftentimes have to play out. But for future creditors, it's a really, really powerful thing. So with that being said, I'll share one of these horror stories. So we have a client at our firm actually that owns a number of fast food restaurants. He's a franchisee, and he got himself way over leveraged. He owed over $10 million in debt, and the franchisor was going to call all of that and was going to foreclose on a bunch of his restaurants. And so we were able to do a bunch of asset protection planning for him utilizing both onshore and offshore entities. And once all of this was done, and this was done after the contracts were done, after the debt was incurred, as the bank was, or as the franchisor was looking to foreclose on his assets, we were able to create enough leverage so that the franchisor would come to the table and renegotiate all of his debt, which he's currently paying off. So instead of losing everything, we were able to create a situation where he's able to keep his franchises and come to a workable solution with the franchisor to continue to operate. So,
wow.
Yeah. So
there you go.
So that's just an example, right? And again, all of it, it's not that he was able to avoid the debt completely, right? He incurred it. He needs to pay it back. But when you're able to take options from the other side off the table, it makes them more conciliatory and willing to bargain with you, because again, if they can just take everything, they might wield that power. If you take that power away from them, then it perhaps puts you in a much better negotiating position. So
awesome. It's all about leverage when it comes to negotiating tables. So
yeah,
definitely
exactly.
Appreciate you sharing that.
Yep.
All right, Brian. Well, again, I really appreciate your time. If you wouldn't mind, just let the listeners know how they can learn more about your firm or any other information that you want to share with them.
Sure. So, if you have any specific questions about asset protection planning, feel free to contact me. My phone number is 714-704-4828. Once again, 714-704-4828. Or you can email me at Brian, B-R-I as in Isaac, A-N, at barthattorneys.com. So that's B as in boy, A as in apple, R as in Robert, T as in Thomas, H as in Harry, attorneys, ATTORNEYS.com.
Awesome. And we will include all that information in the show notes page. Brian, thanks again. I learned a lot. Really appreciate it.
Yeah, Hunter, really appreciate the opportunity. And let's get some time on the books to reconnect. I'd love to chat about, what other opportunities we might have to collaborate together.
Perfect. Let's talk in a few months.
All right. Sounds good.
Have a good one.
All right. Take care.
All right, listeners, thanks for checking out the episode. As always, the contact information for our guest will be available in the show notes page, which is hosted on SoundCloud, iTunes, and Stitcher. Don't forget, if you want access to some of the free goodies that I'm talking about at the beginning of these episodes, like free ebooks, weekly investor emails, and articles about some of the most important investment-related topics, make sure that you have created an account with CFC, because this stuff is automatically available. You can do this by going to cashflowconnections.com and signing up as an accredited investor. Of course, if you have any questions, feel free to email me at hunterthompson@cashflowconnections.com. Thanks again.